All right, welcome back to the Law and Crime Network, Law and Crime Report. My name is Bob Bianchi. I'll be hosting the show. We've got a lot of great topics and some great guests today. We're going to start off right now with Derek Chauvin. That is the former officer who had his knee on the neck of George Floyd, has been bailed out on a $1 million bond. So I want to introduce one of our guests right now. We're going to have two today, but the first one is Imran Ansary from New York, a former prosecutor and criminal defense lawyer extraordinaire. I always love having him on as a guest. Welcome to the show, sir.
Thank you, Bob. Thanks for having me.
Yeah, so there's a lot of controversy about this, Imran. It's about 5 months since he's been in, a little over 5 months. There was this hearing. He made bail. And I know that one of the attorneys on the civil case, I believe it was Ben Crump, had made a comment that there's two systems of justice here, and he's out on the street, and he shouldn't be. Imran, I've been trying to drive this home to our audience for a while, that this is a common procedure that occurs in all cases, a cop case being no different. And sometimes I get a little nervous that we're throwing a baby out with the bathwater here, because there's lots of criminal defendants, black defendants, white defendants, and all those in between that are allowed to bond out on charges, and $1 million is generally about the number. What are your thoughts?
Yeah, no, listen, I expected the outrage from the public at, this notion that Derek Chauvin, after the whole George Floyd incident, after everything that has gone on after this horrible incident, is out on bail. When I saw that headline hit, I was like, wow, there's going to be possible protests. People are going to be outraged. But if we take ourselves back, take a step back, and just do a legal analysis on what happened here, it's really not surprising. So the judge, in considering whether to grant bail or bond, has to really look at one thing: whether that defendant is a flight risk. The judge in this case made a determination that Chauvin is not a flight risk. And if he is granted bail, bond makes that bail or bond, which he did, he would not be a flight risk. Would he return to court if he was released? The judge made that decision. And although it's shocking, and although it may outrage a lot of people, we as attorneys, when we look at this, we could do an analysis here. Was this a horrible crime? Yes. Are the charges warranted? I'm going to say yes. But whether he's out on bail or not is a separate and apart determination by the court altogether. They found that he wouldn't be a flight risk. They made a determination that 1 million was the right number to secure his next appearance at court. He made it. He made it through a bondsman. And now Derek Chauvin, he's not going to be roaming the street. I think there's conditions on his release. I think he has house arrest. So it's not like he's going to be freely going on vacation, yada, yada, yada. No, he's under house arrest. There's conditions on his bail or his bond. And although it shocks many people out there, because there's a lot of emotion here, it's really polarized the country. It's really not that surprising when you look at Derek Chauvin, do that analysis. Is he a flight risk? And consider the fact that he has no priors, that he's a former officer, that really he has the public scrutiny on it. I'm not surprised that he was granted bail.
Yeah, and that's exactly the point that I'm trying to stress with people. He is a defendant in a case, and he is presumed innocent, despite the outrage that's out there, and we all get it. But this is something that it's not two systems of justice. This is what goes on every single day in courtrooms that have far less cases of notoriety. And Imran, what you can do as a prosecutor is argue that because of the seriousness of the offense, that could increase the likelihood that he's a flight risk. But if the court doesn't buy that, and the court feels that they can place conditions on him, including a $1 million bond, this is not an atypical thing. So while there's outrage, we get it. We, again, don't want to throw the baby out with the bathwater here and change all of those constitutional protections that are applied every day for minor defendants on less notorious cases. There is also an argument to be made, Imran, that there are some states, when we're talking about criminal justice reform, that want to remove the cash bail or bond money requirement and rather do a risk assessment. We did that in New Jersey. I know New York did it. We're doing it a little bit differently. Talk to us a little bit about those changes in this bail system that I think more competently evaluate the likelihood of risk of flight as well as danger to the community. At least that's the standard we have here in Jersey, which would definitely give prosecutors more teeth in keeping people in. Although in reality, it's let a lot of people out, because I can remember as prosecutor, Imran, we had people on bail, a $200 bail, that couldn't make it on a minor offense, that stayed in jail sometimes 2 or 3 years waiting for trial.
Yeah, no, Bob, listen, it's sweeping the nation. And you honed in New Jersey, but particularly New York. And, I was a former prosecutor with the Brooklyn District Attorney's Office. So I handled many arraignments where I would be asking for significant bail on a defendant, and then the defense attorney. And now I do some defense. And obviously, we're arguing the other side. We're saying that this individual is not a flight risk, that they will return to court, that they've invested in private counsel if that's the case, and they're going to return. But as a prosecutor, you're going to be looking for a bail. You know why? Because at that point, right, and this is pre-reform, you're looking to secure the defendant in prison. You're looking to argue and do your job as a prosecutor, and make sure that the streets may remain safe. I don't want to get too political here. That's why I'm sort of a little guarded with my words. But what we have now are sweeping bail reforms. Here in New York, you find more often that at arraignments, a defendant will be released rather than being detained on bail. So, sweeping bail reforms, but like you say, there's really shouldn't be two sets of justice. I know this is a horrible set of facts. It's really taken the nation aback. You have a lot of advocacy because of what happened. But if you really look at this, it's a good thing. And I say that because if the judge made a proper determination that this individual was not going to be a flight risk, that he is not a threat to society other than what he's already charged with, then the determination was correct. And justice and the determination of whether someone is granted bail or remand was applied evenly.
Right. Okay. Again, he is presumed innocent unless until convicted by 12 jurors beyond a reasonable doubt. And let's face the most practical point here. This was a big win for the defense, because representing a client that's out of jail is far more easier than representing one that's in jail. The access to the lawyer and the client is crucial. So there was a big win for the defense with respect to that. Let's move on to a clip of the Attorney General, Keith Ellison, on September 11th, 2020, that he had given after a pretrial hearing for the 4 officers.
Today's hearing marked another step in what will be a long process toward justice. I think the Floyd family, the community, and the people of the state of Minnesota for their understanding and patience as we make our case and continue to move forward to a trial. At this time, I'm not in a position to answer any questions. Those of you who know me know that I do answer questions. However, today's court proceeding is a mention to consider motions that have been heard by the court, and therefore I will not comment on them. So that's all I have to say. Thank you.
Imran, that's all he had to say, but there were a lot of other people that had a lot of stuff to say there. Boy, I can tell you, having been a person that had to stand up and give those kind of press conferences in controversial cases, I never dealt with anything like that. You could barely hear him speaking. I wonder whether or not these things are efficacious for them to do in an open environment like that. I am concerned about the fairness of a trial, whether I'm a prosecutor or a defense lawyer. People clearly have a right to protest. But we're not really getting any valuable information there. Now, one of the issues that came out in that pretrial hearing was whether all 4 defendants should be tried together. That's what the prosecutor wants. And the defense lawyers want to have separate trials. Can you talk to us a little bit about what each side's position is and tactically why they're arguing for different things?
Sure. So the prosecution would like to try these defendants together. That is common when you have a multi-defendant case and you want to present the evidence in one set on the people's case. You're going to have witnesses testifying once. They would be testifying in regards to the facts and the observations that they had as to all of the defendants. And that would be a unified trial with all multi-defendants having a single trial. Sometimes you'll have separate juries deciding certain defendants and hearing evidence piecemeal. But the defense would always want, in a case like this, a separate trial for each defendant. They would not want the facts coming out on one defendant that may be prejudicial to their client, and a jury determining the guilt or innocence of their client based on the set of facts for another individual that may be incredibly prejudicial to their particular client. The prosecution usually wants to try a multi-defendant case in one single trial. They're presenting evidence, and it tends to strengthen one case against one particular defendant if it's a certain kind of case where the evidence will tend to establish the guilt of another defendant. And again, a defense attorney usually wants to have a separate trial. That way, they're ensuring that the prejudicial information that may be coming out on testimony or evidence as to another defendant won't be prejudicing their client, and their client won't be convicted on evidence that may establish the guilt or innocence of the other defendant here.
Yeah, I'm going to take a contrarian view on this. If I were representing some of the other officers, not Chauvin, I may want to be in that courtroom with all of them to give the jury the ability to be able to convict Chauvin and maybe some of the other ones, like, for example, that Officer Tao that was out there, and try to separate his conduct. Listen, the fact of the matter is each jury, even if it's separate and independent, is going to see that tape, is going to see that evidence. It's coming out one way or the other. And I want to give that jury that emotional distance to be able to make a conviction on one of the more culpable clients with respect to that person, and maybe give my client a break. That's the way I see this particular case right now. But also, just real quick, I want you to talk about, we're going to go to break, but unfortunately, there are also evidentiary issues that apply here that may limit the prosecutor from getting certain information out if they're all tried together. It's really in the weeds stuff. So maybe we'll reserve that for some other time. Stay with us. We got a lot more coming up here on Law and Crime Report. We're going to take a quick break, and we'll be right back.
We are here to announce the indictment of Alexander Konta and Al-Shafi al-Sheikh. Konta and al-Sheikh were members of the notoriously brutal ISIS hostage-taking cell that became known as the Beatles, a name their captives gave to them because of their British accents. The defendants are charged with terrorism offenses related to hostage-taking and killing of 4 Americans, as well as citizens of Great Britain and Japan. For over a year, Konta and al-Sheikh were held in Iraq by the U.S. military under the law of armed conflict. I'm pleased to confirm that they are now in FBI custody and will soon appear in federal court in the Eastern District of Virginia. Today is a good day, but it is also a solemn one. Today, we remember the 4 innocent Americans whose lives were taken by ISIS. James Wright Foley, Stephen Joel Sotloff, Peter Edward Kasich, and Kayla Jean Mueller.
All right, that is John Emmers, who is an assistant attorney general, announcing those charges. Just to be clear here, these are British nationals, and one of the agreements that they had was, in order to extradite them to the United States, Britain required that there be no death penalty. This is a common thing that we've seen here on some of the cases that we've covered here on the Law and Crime Network when we're extraditing from foreign countries. So they're only facing life in prison. I want to throw right now to a clip of G. Zachary Terwillinger, I apologize, U.S. Attorney, Eastern District of Virginia, that also discusses these really amazing charges that the United States government for a long time has been trying to accomplish, and they did, in fact, accomplish. Let's take a listen.
Yesterday, an 8-count criminal indictment was returned in the Eastern District of Virginia that charged 2 alleged terrorists, Alexander Konta and Al-Shafi al-Sheikh, with the following felony offenses: conspiracy to commit hostage-taking resulting in death, hostage-taking resulting in death, 1 count for each of the American hostages: James Wright Foley, Kayla Jean Mueller, Stephen Joel Sotloff, and Peter Edward Kasich. Count 6, conspiracy to murder United States citizens outside of the United States. Count 7, conspiracy to provide material support to terrorists in the form of hostage-taking resulting in death and murder. Count 8, conspiracy to provide material support to a terrorist organization. If convicted, the defendants face a maximum penalty of life in prison for each count of conviction. Pursuant to well-known protections provided by our constitutional republic in its system of criminal justice, Cote and Al-Sheikh are presumed innocent unless and until proven otherwise.
All right, so we have another guest with us, Adam Konta out of New York, former prosecutor, criminal defense attorney, just like Imran. So two great guests, two great legal analysts. Adam, welcome to the show. Let's look into what extradition is and explain a little bit more in depth the process of extradition and how it is that countries can place restrictions as a condition to extradite individuals to the United States.
Sure. Good to be here. So extradition is essentially trying to get someone from one jurisdiction to another jurisdiction. Sometimes there's very little stumbling blocks. For instance, here in New York City, we have extradition with clients, defendants from New Jersey, Connecticut, Massachusetts all the time, and that's relatively easy. But there is still levels of paperwork, levels of bureaucracy that gets in the way, even of those what seem very simple extraditions. In this situation, when you have an international terrorist, allegedly, you have multiple countries involved, there are significant stumbling blocks at times. And a lot of times countries have no treaties with the United States to extradite at all. Fortunately, we have a very good relationship with the United Kingdom. And so through some diligent work, we've been able to do this. But although it's somewhat rare, they can ask for these certain types of restrictions almost as a tit for tat. Yes, we'll let you prosecute in the jurisdiction that you want to prosecute in because you believe you are the most aggrieved party. But we ask for this in return. And in this case, it's taking the death penalty off the table. So a little unusual, but a fairly small thing to give up just to make this run as smoothly as it's run so far.
Yeah, you know, Imran, but it can get a little, like the great analysis, Adam, but it can get a little fuzzy. Remember that case we covered gavel to gavel here at the Law and Crime Network? The name of the case is escaping me right now, but the mastermind of the plan of the murder was in Mexico, I believe it was, and the other defendants were captured in the United States. And one of them who was less involved, less culpable, I guess, or as culpable, they were in a conspiracy together, was facing the death penalty. But because Mexico refused to extradite if we were going to impose the death penalty, eventually the United States relented, got a significantly lesser sentence. I mean, it can lead to some anomalies in terms of disparity of punishment in circumstances like that.
Yeah, no, absolutely. And it really all depends on the treaty that the United States has with that particular country. That is why you hear about people going on the land that committed a crime in the United States. And you always hear them going to certain countries, right? That's the big movie story. Someone's committed a crime, they're going down to a certain country. Well, that's because the United States doesn't necessarily have a favorable, if any, extradition treaty with that particular country. Here with the United Kingdom, it's a long entrenched relationship between these two countries, and the extradition treaty between these two countries is fairly open. But yes, it is a give and take. If in the case that you just referred to, Mexico had as a condition, well, yes, we recognize that he has to answer for crimes in the United States allegedly committed. But if we're going to extradite him, if we're going to give him the body, give you the body and produce the body, if you will, you're going to have to come to terms with what we want. And often the country will impose the certain nuances of their own justice system on the United States. Here, the United Kingdom the death penalty is frowned upon. It's abolished. It doesn't happen. And this is a great example of where the extraditing country, the country that is producing the body, is imposing a certain nuance of their legal system on the United States. But I think it was compelling enough that we wanted these individuals here in the United States. You hear the Justice Department coming out with these strong statements, and I think the message is clear. If you have allegedly committed crimes against Americans, whether you be in Iraq, Syria, the United Kingdom, or what have you, we're going to be looking to bring you back. We're going to be looking to have you answer to the justice system here. I do love the condition, though, that we do not forget the Constitution of this United States. He made it clear that they are presumed innocent, that they have the constitutional benefits that this country has given its citizens, and even people who are not citizens but brought into our justice system.
Yeah, excellent analysis. Well, the U.S. Attorney for Eastern Virginia also had more commentary about this monumental arrest. Let's take a listen.
Their alleged criminal acts include conspiring to commit hostage-taking resulting in death and conspiring to murder American citizens James Foley, Kayla Mueller, Stephen Sotloff, and Peter Cassidy. As part of the conspiracy, their vicious acts and those of co-conspirators Mohammed Emwazi and CC1 are alleged to include the following: forced witnessing of murders, mock executions, shocks via electric taser, beatings, amongst other brutal acts. Also a well-established principle in American jurisprudence, co-conspirators, like these defendants, may be held liable for the foreseeable acts of their co-conspirators, such as Emwazi, that took place during the course of the conspiracy. As stated in detail, Kote, El-Sheikh, Emwazi, and CC1 facilitated hostage-taking, ransom demands, abuse, and the murder of Americans, Europeans, and Asian citizens in order to further their terrorist agenda and that of ISIS. The brutal acts of beheading were captured by the ISIS media propaganda machine and disseminated to achieve their aims of jihad. Further, as detailed in the indictment, part of the alleged horrific conditions of confinement, the self-proclaimed leader of ISIS, Abu Bakr al-Baghdadi, also made it a point to repeatedly sexually assault American citizen Kayla Jean Mueller. As you know, al-Baghdadi was killed on or about October 26, 2019, in a United States military operation named in honor of Kayla and her birthday, August 14th, Operation 814. For these acts, these two alleged terrorists will now face the American justice system.
All right, Adam, sometimes, lawyers, you get up there, you give a press conference, there's a lot of technical language that's thrown out there, and the public has a general idea of it, but not really a specific one. Talk to us a little bit about what a conspiracy is and the importance of that conspiracy charge, as he kind of quickly went through the idea that you may not have actually done the act, but you were involved in, participated in some of the planning or execution of that act.
Sure. So obviously the crimes that he just described are both incredibly famous and incredibly heinous. But as you said, that doesn't mean that these two individuals specifically were involved hands-on in those. That's where the conspiracy comes in. The best way that I describe a conspiracy to a layperson is a bicycle wheel. If you can picture spokes on a bicycle wheel, one spoke might not have anything to do or touch with another spoke, but they're all still part of the wheel that is going around. And each cog, each spoke in that wheel is necessary for the wheel to act as a whole. So even though one person might be in charge of distribution, and let's just use a drug conspiracy. One person might be in charge of distribution. One person might be in charge of getting the drug. A few people might be in charge of selling the drugs. Those people might not know each other. They might not have any connection to each other, but they're all still working on the same wheel, so to speak, and the same goal of criminality. And that's what these two are doing. Even though they might not have even known Baghdadi, or they might have had a very close relationship, it really doesn't matter if they're all working towards the same goal. And this goal happened to be one of creating mass terror and murder. But that's how a conspiracy relates to these two individuals in this case.
All right, Adam Konta bringing the wheel to the Law and Crime Network. Great analogy. Hey, folks, go on Facebook Live right now. We're streaming. Put in your commentary. We always love to hear what it is that you have to say. We have more about the Boston bomber, another case of terrorism that's going to come up on the other side of the break. Stay with us. We'll be right back. Oh, well, Bill Barr's Justice Department wants to go to the Supreme Court after getting a negative ruling on the Boston bomber, Dzhokhar Sarnov's case. Essentially, what has occurred in a court below is that they threw out the death penalty sentence. Bill Barr has made a commitment that he wants to go to the Supreme Court, and he wants to have that ruling reversed. And even if the Supreme Court does not reverse that ruling, defense lawyers in the case are saying, just let him have a life sentence and let that be the end of it. But they have made a commitment, no. If we've got to try the death penalty part of that case over again, that is exactly what we're going to do. Imran, so talk to us a little bit about the facts of why did the court throw this case out? It had something to do with jurors and the manner in which the judge instructed those jurors. And what do you think the likelihood is that the Supreme Court will pick this case up?
Yeah, sure. No, so this, this was reversed basically because of certain things that occurred during voir dire or jury selection. And the court found that there were certain questions that were proposed by the judge to those potential jurors that were not necessarily fair to the defendant. And that's why they reversed it. They had reversed the convictions. This is purely the penalty phase. So Dzhokhar Tsarnaev is still on the hook for what he's been convicted for. It's essentially the court is sending this back to the trial court, if you will, for a sentencing phase retry, if you will. So they would have to pick a new jury. They would have to put this evidence before. And it would really be a little jarring to the victims or the victims' families in this case, because they will have to be brought back into court. And that's going to be something, a determination that prosecutors are going to have to make. Are they going to be content with life in prison, or are they going to still be seeking the death penalty? But I think what we have with Bill Barr's DOJ, what we see is absolutely they want to be taking this up to the Supreme Court so that the Supreme Court is upholding the death penalty. So I think, let's say the Supreme Court hears it, grants certiorari, hears this case, and reverses it and agrees with the lower appellate court and sends it back. And the prosecutors have to go back, present evidence to the jury, and seek the death penalty on the penalty phase. I think if it's Bill Barr and his DOJ, they're going to be doing just that, and they're going to be looking to seek the death penalty again.
Yeah, while Adam was a death penalty prosecutor myself at a certain point in time, although I'm not a fan of the death penalty, any longer for a number of reasons after having been through the system for a long period of time. If you do file a death penalty case, especially a case of this notoriety where such random people were killed and so many that were injured, there is no doubt in my mind that if the Supreme Court refuses to hear the case or agrees with the lower court that there needs to be a new death penalty proceeding only, like Imran says, it's not about the guilt part, it's just about the sentencing part. There is zero doubt in my mind they will go forward with it and they will secure a death penalty conviction. But I may be wrong. What are your thoughts?
Well, I think they actually got off lucky so far, because what really happened is the judge refused to allow lawyers to get into potential jurors' biases and just asked a very general question of, do you think you can be fair in this trial? I mean, that's such a broad question for such a serious case. I think they're actually extremely lucky that they didn't reverse the guilt portion as well.
Yeah.
And we're just talking about the sentencing portion.
Yeah, Adam, that is, I'm sorry to cut you off. Yeah, now I was wondering the same thing. If there was something that was wrong during that process, why did it not go to the guilt phase of it? That is an excellent question. And if you go to the Supreme Court, I am sure the defense, what do you think, are going to raise that very issue? And man, maybe there's a potential the whole thing gets thrown out.
Yeah, I think they have to be careful. I mean, if you're going to say that jurors, this is unfair to a defendant, and every defendant, no matter how heinous their crimes are alleged to be or proven to be, deserves every advantage of the law, regardless of race, creed, or color. And if you get to this point where you've decided that jurors were unfairly screened, well, then how is the whole trial not tainted? How is the entire process not tainted? And I think they have to really be careful because, they could bite them. They want that death penalty so bad, but I don't know if it's worth it.
Yeah, I great point, Adam, and I think they're going to go forward anyway. Hey, we got to switch gears a little bit. The Parkland families are outraged after a school district that is defending a lawsuit that the victims' families have filed in the case, and in that lawsuit, the defendants' attorneys and I assume insurance companies are asking for all sorts of documents to prove that they are actually suffering mental illness or emotional disturbances as a result of the shooting. The parents are outraged by this, and it's going to be an ongoing legal battle with regard to mental anguish. Guys, I'll give you my point after I hear from you, Imran. What do you think about the requests that are being asked for medical records, psychiatric records, and all sorts of other records compared to other cases that you've handled? And whether or not they're going to be successful in asking a judge to stop the defense from getting that information?
Sure. Well, Bob, I do a fair amount of civil work also. And, although it seems very insensitive for the defense to be requesting these medical records and these treatment records, it's actually pretty par the course. It's a horrible tragedy what happened down in Parkland. These families have really been ripped apart by the tragedy that they've been affected by. But let's put the sympathy aside for a second. And I don't mean to sound unsympathetic because it's a horrible thing they've gone through. But when a plaintiff puts at issue their mental health in courts in New York, across the country, the defense will be entitled to medical records, to treatment records, in order to either rebut that claim or to see that it is a bona fide claim and deal with that on the defense. It's not an uncommon thing. It seems unsympathetic when you hear about it, but the plaintiffs, by claiming these damages, have put it at issue, and it is not uncommon for the defense to request these medical records. In fact, a court will often easily grant the defense access to these medical records. The plaintiff will be providing HIPAA authorizations so that the defense can access these medical records because it is the plaintiff themselves who have put it at issue.
Yeah, look, I agree, and it's not being unsympathetic, but I go back to let's not throw the baby out with the bathwater. This is what is done in cases. This was a claim. I've done plaintiff's work myself that was made by the plaintiff, and the defense has a right to test that claim. So there is nothing unusual happening here, although I understand the frustration with it. Adam, if I'm reading this correctly, and you can either comment on what we've been talking about, or I'm being told that there's a pot of money of $300,000 that's available and no more than $300,000 for these families. I mean, how much of this, if that is in fact accurate or anywhere near accurate, and correct me if I'm wrong, why aren't they just paying this out and moving along? Kind of to Imran's point, it's not a legal point, but it's just a moral point, an ethical point. These people were victimized. It's $300,000. These cities are given millions and millions and millions of dollars in other cases. Why not here and just move on? How much money are they spending in lawyer fees to protect that pot of money? It's craziness.
No, you raise an excellent point. And, we do a good bit of civil work as well. And I totally agree with what Imran is saying, that it's very normal to request medical records. It would be insane if you didn't request medical records. Now, they're also asking for proof of media appearances, which I think is a bit far. But the problem is the optics of it. And if you're doing something very normal as a law firm to try to collect evidence, to put together a case, and oftentimes you can even say, listen, we need to know how much things cost, funeral expenses, et cetera, psychiatry bills, so you're adequately compensated. We want this will help us adequately compensate you. If that's the argument, fair enough. But on the other hand, which is what you just brought up, we're only talking about $300,000 that's going to be split up amongst the families. If we're only talking about $300,000 amongst these people for these tremendous tragedies, then I do not understand the point of putting these families through this whatsoever. Because gathering medical records is going to tell you that these families deserve well more than $300,000. But if there's already that cap in place, then this seems entirely unnecessary, and it does seem borderline harassment in this scenario.
And to be fair, the lawyers for the plaintiffs are arguing that they believe in reading and interpreting the policy that each individual plaintiffs should be able to have up to that amount of money. But I believe a court so far has been in favor of the defense on that. So that is a really important tactical issue as to how much money is available and how far you're going to go with respect to this. Guys, listen, we've got a lot more on our plate here at the Law and Crime Network, including this huge controversy about Netflix's film Cuties. I don't know if you know about it, but if you haven't, stay tuned because we're going to talk about it right after the break.
Vous dites quoi à la gare? On va danser au concours. Je danse avec vous. Quoi?
Okay, there you have it. Netflix is coming under not only a major scrutiny, and I've seen some promos that are even worse than what you're seeing there by far. Young girls scantily clad in sexually suggestive positions. Well, a Texas grand jury has indicted Netflix because this is a story about an 11-year-old Senegalese girl as she's coming to her own with her age, where she's trying to comply with the religious dictates of her family, but by the same token, trying to fit in with other girls. So that's the theme of this movie. What this Texas grand jury has said is that these were sexually suggestive. They violated the lewdness rules. And I've got two great guests here to talk about it. Imran, look, I'm conflicted about this. We have these beauty pageants that have been going on for years. When you talk about the law of lewdness, it talks about a lascivious exhibition of the genitals or the genital area. There's a number of factors that can be considered about, are they clothed or are they partially clothed or not? Are they in sexually suggestive positions? And does it excite the quote unquote prurient interest of the viewer? Sometimes these cases are hard to prove. I'm just curious, if you were prosecuting this case, would you also be concerned, because I would imagine the defense lawyers are going to be presenting all sorts of things that are out there like this that people don't get indicted for. So while it is distasteful and I think a terrible thing to put on, are they going to be able to defend this case? Is the prosecution going to be able to win this case?
So, Bob, I find this absolutely fascinating. You have a film that was produced and filmed in France. Netflix got the distribution rights. They put it on the platform here in the United States. And you have a Texas state court in Tyler County indicted Netflix for the distribution and the dissemination of this film. I find it absolutely fascinating that a state court in Texas has gone out of its way to present this evidence to a grand jury in Tyler County, achieved an indictment, secured an indictment, and now Netflix is going to have to go in and defend this. How are they going to defend this? Well, you got to think about the location where this case is pending. Now, I haven't seen this film. I know Netflix is doubling down on their defense on it, on why they distributed it. I know that the director of this film has said that it was the opposite intent, that she actually wanted to show that young girls, and the sort of expectations that society places on them to look a certain way or act a certain way. And it was her opposite intent in producing and directing this film. But I'm really curious because now Netflix is going to be having to defend this in Tyler County, Texas. Now, I think that Tyler County perhaps has a population base that may be more conservative, that may have religious morals that they adhere to, and they're going to be looking at this case, looking at the defense that Netflix puts on under that lens. Will Netflix look to remove this to federal court? Perhaps. I think that may happen. But it's really fascinating how you have a state court in Tyler County, Texas, indicting Netflix for a film produced in France. It's fascinating how they're going to defend it. Well, I think that they're going to have to look at their jurisdiction that they're defending the case in.
Yeah, sure. And Adam, it can become a slippery slope. What's next? Are beauty pageants next? Are films with young women on the beach in scantily dressed bathing suits? On and on it could go. But one thing that Imran said that I also want to make sure our audience knows that when I described what the law is, generally speaking, about exciting the purient interests and the manner in which they're clothed in sexually suggestive positions, it also requires that there be no literary, scientific, or otherwise valid purpose, if you will, for producing that kind of film. And what they're trying to say here clearly is that they're trying to show the stresses and troubles of an 11-year-old girl coming of age trying to fit in with other people. So even that's two hurdles that the prosecution has to overcome. What are your thoughts about this whole matter?
Yeah, Imran used the word fascinating, that this is in state court in Tyler County. I'm going to use the word suspicious because it doesn't make sense. And I think that someone above Tyler County is the cause of this, whether it's Ted Cruz, the state attorney general, I don't know. Because it is such a slippery slope, especially in a state like Texas that is heavy into child beauty pageants, which I think raises a lot more eyebrows than this film. The purpose of the film is to shine a light on the social media issues facing young girls. This happens to be a Senegalese Muslim girl that's being depicted in this film. I just don't think Texas would have indicted a beauty pageant that had a similar promotional poster, which seems to be really the basis of why they chose to indict Netflix for this film. It seems very hypocritical and suspicious to me, and I think they're going to have a tremendously difficult time if they think they're going to successfully prosecute this case.
Yeah. Okay. Well, we got to move on because we got another really sad case. A 65-year-old Donald Lewinson has been charged with the death of an 80-year-old man. This happened, and boy, I've handled so many cases like this in a barroom context in which an argument started over somebody not wearing a mask, and the victim, the 80-year-old, was upset about that, and he was upset about the manner in which the defendant was treating the bar staff. And during that argument, the 65-year-old pushed the 80-year-old victim to the ground, who suffered a seizure and ultimately died in the hospital. And he is now the defendant being charged, Donald Lewinsky, 65, with criminally negligent homicide. Let's go to a clip of the attorney after they came out of the courtroom after he entered a plea of not guilty on behalf of Mr. Lewinsky.
My client and his family, I don't know if remorse is the right word, but they are so sympathetic to the victim and the victim's family. Obviously, their heart goes out to them, and they wish only give them only their deepest sympathy for what occurred here. Obviously, their hearts go out to the family.
Yeah, Imran, let's talk about this a little bit too, because again, people can get confused. Criminally negligent homicide. Generally, these terms are interchangeable in many of the states that we're in, but it requires more than just mere negligence. There are so many bar fights that happen where somebody does not intend to seriously injure somebody, but somebody in fact does get seriously injured. What do you think are the elements that the prosecutor, the things the prosecutor is going to have to prove in order to sustain this charge as being something that rises to the criminal level as opposed to just mere negligence, which would be a civil case?
Sure. In New York, to show criminally negligent homicide or negligence that rises out of the civil arena and into the criminal arena, you have to show that it's really gross negligence, a reckless disregard, if you will. Here, these bar fights, you mentioned these bar fights, and we hear about these cases where you have two individuals, they get in an altercation, one person throws a punch, they land that punch, and that person falls down, hits their head, and they die. And they're really horrific sort of cases. But when you take that, and again, this is sort of the theme of today's show, where you hear about things that really shock the conscience or gain your sympathy. But when you put it in the court of law and you analyze it under the law in this country, in the state, you sometimes don't really get from point A to point B in terms of a harsh punishment, in terms of remand, not bail. And with these one-punch homicides, you often have a defendant who ultimately gets a great plea deal, ultimately is possibly acquitted at trial of homicide, and you may end up with a simple assault because the prosecution has to show that that individual had the intent to cause that death. And if they can't do that, then a homicide, unfortunately there's a death, ultimately comes down and moves down to a simple assault. And this is what we may have in this case. They may not be able to show that this individual with that one shove which unfortunately left this person deceased, had the intent to cause that death.
Absolutely agree. Guys, I'm going to have to end it there. It was so great having both of you guys on the show. Stay tuned for our regularly scheduled program. This is Law and Crime Report. You can find me at rbianchi ESQ on Twitter and Instagram.